Episode number 70 of At Your Service with Haber and Martinez. I'm Haber. Off to my side is Martinez. And today we're going to have a show entitled, quote, I'm Just a Bill Until Signed into Law. We're going to deal with new laws in Florida that took effect this month, July 1st of 2023. Not all of them, because there were more than 200 bills signed into law. But we are going to isolate 7 of them that Ed and I will talk to you about. Ones that we think are either interesting or significant. Not that they aren't all significant, but when it comes to what I like to call the 3 C's, cops, courts, and constitutions, we're really only interested in these particular ones for purposes of our show today. So how you doing, Ed? I haven't seen you in quite a while.
I know, man. I haven't seen you in person.
Out of respect, I decided to get dressed up just like you today.
Well, I wear enough ties when I go to court.
Not to mention your time at Helga's House of Pain.
Is what?
At Helga's House of Pain. A lot of ties there too. Zip ties.
So I like to keep it casual to let people know that we are men of the people.
That's correct. We're blue collar lawyers.
That's right.
So we're going to talk about a bunch of laws, 7 of them to be exact, new laws. But I want to talk a little bit before we get into that. I want to do a little civics class for our audience. When you and I went to school, they taught civics. My son, who just graduated this past June, probably can't spell civics, much less define it. Although I know he can because I've physically taken him on personal tours through the history of the United States. But through academia, it's really gotten lost in translation from where we were. And what I mean by that is many people don't understand the legislative process. How does a law come to be a law? Again, you and I learned that in grade school.
Actually, no, that's not where I learned it.
Where'd you learn it?
Saturday morning, Schoolhouse Rock.
It's very funny you should mention that because we're going to roll that Schoolhouse Rock. I'm Just a Bill. I have it queued up.
That's Schoolhouse Rock.
That's actually episode number 1 of season 3, which aired on September 18th of 1975. I'm Just a Bill. Yes, I'm only a bill.
Love that.
It's important that folks understand that because I talked about in our promo materials a little bit about the difference between something that is complex and something that is complicated, right?
Right.
When something's complex, it's not necessarily complicated. Those two things don't go together. Right. Although something complicated is almost always complex. Right. Complex really refers to something with many components. It's a process, right? A protocol, a procedure. Whereas something that's complicated has a higher level of difficulty. So when we talk about the legislative process, and I could run through it and give you the 8 steps as are outlined in the legislative process.
I would much rather see Schoolhouse Rock.
We're going to, but I'll give it to you this way real quick, just so you know. Somebody drafts a bill. Somebody prepares language that they want to propose as a bill, and then that bill is introduced in whatever body it is. Usually it starts in the House of Representatives. Then it goes to a committee. There's committees for everything in the House of Representatives. Then the committee will probably assign it to a subcommittee to review it. It gets marked up, maybe it gets changed, maybe it gets approved. Either way, it gets voted on. If it goes through committee, then it gets referred to the full chamber. And if it gets approved by the chamber, then it goes to the next house, over to the Senate for approval. And then if it passes there, ultimately it winds up on the federal level on the president's desk, on the state level on the governor's desk. But the process is virtually identical. Again, it is not necessarily something that is complicated, but it is complex. So all of the laws that we're going to talk about today have gone through this procedure. Somebody proposed them, somebody drafted it, somebody brought it up, it got assigned to a committee, the committee revised it, agreed to it, amended it, whatever they did, ultimately they gave it their stamp of approval. Then it went to a full vote for the body that it was in. Some of these bills are called HB because they started in the House. So it would be a House bill. Others are SB. They started in the Senate. They're Senate bills, or they're House bills that got amended in the Senate. But either way, once they're finally approved by both chambers, they go over to, we're going to do it statewide to Governor DeSantis, who has executed and signed into law all of those bills.
Michael, I got to interrupt you because I'm channeling my inner 2-year-old. I have impulse control. I want to talk about these bills. I want to see Schoolhouse Rock.
Okay, let's have our producers roll Schoolhouse Rock. So I'm just a bill. Go ahead, roll it. I don't hear any audio.
We don't hear any audio. Oh, come on. You got to give us audio.
Producers, you got to start re-roll it with audio. We can't hear anything.
We have no audio.
Hello, Mr. Producer. I don't know if maybe he can't hear us.
Well, if you can't get audio, cut it off, and then we'll start with the bills until you get it back.
Yeah, let me send him a chat while we're doing this. No. Oop. No. Audio. Will have to be implemented in post. I don't know what that means. Well, we may not be able to get audio. I don't know what the problem is there.
Start with the bills. Which ones you want to do first?
Well, just so the folks know, if you look at our promo materials, I put a link to the video. You can watch it on your own. It's a good watch if you've never seen it before. It's cute.
And let's be honest, it explains it fully in detail. It tells you exactly how bills become laws.
You know, it's funny, Ed, and you know, we're not a political show, but and so I'm not making this a political statement per se, but it is funny how we actually used to be able to learn real world practical stuff on TV, right? Yeah. I mean, you could literally watch Schoolhouse Rock in 1975, 1978, and you would actually learn the legislative process in a 3-minute cartoon. Today, you look at the news and you know, you cannot rely on anything.
You can't. I got on that note briefly. I was listening to the radio today on Sirius Radio, one of the news channels. And it occurred to me, Michael, it gave me a flashback. You know what they said? They came out. It was like, you know, like just a news, like headline news kind of thing. And they come out and say, I forget what bill they passed in Iowa, Idaho, Arkansas, I don't know, somewhere. And all they said was the bill says X. And then they said, and there's the ACLU organization, which is arguing that bill is unconstitutional. That's all. That's the way it used to be. This is the one side, this is the other side, and the newscaster never got involved in telling
no opinions.
Just tells you, listen, this is what's out there. And it took me back to what you and I grew up with, where you heard both sides from any newscaster. You heard both sides, and then later, if there was a point counterpoint show, this is where the opinions would come in. But now everything's an opinion. So,
Ed, you ignorant slut.
That's right. Good. So let's talk which bill you want to tackle.
So our producer is telling us that he may be able to run it. So if you can, feel free to chime in anytime. Just go ahead and run it. Ned and I will shut up. But unless and until that happens, we're going to keep going. So let's go in numerical order. And the first one that I have on my list is House Bill 437, Homeowners' Right to Display Patriotic Flags.
All right.
So let's start with this premise. Anybody who has ever lived in either a condo association or a homeowners association knows what it's like to live in a totalitarian regime.
Tell me about it.
It's really atrocious, the power that homeowners associations and condo associations have to make arbitrary rules, and really you have a very difficult time challenging them. They have all sorts of stuff. They have bylaws, covenants, articles, you know, all fancy language that Ed and I don't generally deal with in our day-to-day practice. But clearly there are things that they don't let you do, and they can be very draconian in terms of things that you might not even think of that are really important. Like, let's say you want to paint your house, but they only allow a certain shade of a particular color in that particular part of your community. So
look at this bill, for instance. You know, when I was prepping for the show and I'm reading this bill, I'm thinking this is a bill that you would normally think you would not need a bill for this. But
you do. Because there's many homeowners associations that say you cannot fly flags on your property.
And you can't fly the flags that they don't like.
I think that's part of why we had controversy here, right? Okay. Because most people, I mean, look, there are always people who are going to get upset even at the most rational of things, right? I want to fly an American flag, and somebody's going to say, no, I don't like it.
Right. They're going to say it's offensive, but the LGBT flag is not offensive.
Right. So what's happened here is the Florida legislature
and so we're clear, or vice versa, right? You have the ones that are like, we should be able to fly an American flag, but you shouldn't be able to fly the LGBT.
But it's right. Either way, it doesn't matter. Or you can even go other stuff, you know, like maybe you want to have a Confederate flag. Maybe you want to have a jihad flag, right? I mean, this is America. You have First Amendment rights. Our producer's telling me that he can run the video now. So let's take a pause for a second and learn how a bill gets passed according to Schoolhouse Rock.
Woo. You sure got to climb a lot of steps to get to this Capitol building here in Washington. Well, I wonder who that sad little scrap of paper is.
I'm just a bill, yes, I'm only a bill, and I'm sitting here on Capitol Hill. Well, it's a long, long journey to the capital city. It's a long, long wait while I'm sitting in committee, but I know I'll be a law someday. At least I hope and pray that I will, but today I am still just a bill.
Gee, Bill, you certainly have a lot of patience and courage.
Well, I got this far. When I started, I wasn't even a bill. I was just an idea. Some folks back home decided they wanted a law passed, so they called their local congressman, and he said, "You're right, there ought to be a law." Then he sat down and wrote me out and introduced me to Congress, and I became a bill. And I'll remain a bill until they decide to make me a law. I'm just a bill, yes, I'm only a bill, and I got as far as Capitol Hill. Well, now I'm stuck in committee, and I'll sit here and wait while a few key congressmen discuss and debate whether they should let me be a law. I hope and pray that they will, but today I am still just a bill.
Listen to those congressmen arguing. Is all that discussion and debate about you?
Yeah, I'm one of the lucky ones. Most bills never even get this far. I hope they decide to report on me favorably, otherwise I may die.
Die?
Yeah, die in committee. Oh, but it looks like I'm gonna live. Now I go to the House of Representatives and they vote on me.
If they vote yes, what happens?
Then I go to the Senate and the whole thing starts all over again.
Oh, no.
Oh, yes. I'm just a bill. Yes, I'm only a bill. And if they vote for me on Capitol Hill, well, then I'm off to the White House where I'll wait in a line with a lot of other bills for the president to sign. And if he signs me, then I'll be a law. I hope and pray that he will. But today I am still just a bill.
You mean even if the whole Congress says you should be a law, the president can still say no?
Yes, that's called a veto. If the president vetoes me, I have to go back to Congress and they vote on me again, and by that time you're so
By
old.
that time, it's very unlikely that you become a law. It's not easy to become a law, is it?
No, but how I hope and pray that I will. But today I am still just a bill.
He signed your bill. Now you're a law.
Oh, yes.
Love it.
So
Jack
that takes us right.
Jack is the singer that sang that little thing. He may rest in peace.
So getting back to HB 437. So what the Congress proposed and the governor authorized as law is a check valve on homeowners associations to not be able to deny you the right to fly certain flags on your property. It's not blanket authority to fly anything you want. So you don't get to fly as a matter of right. Now, again, your homeowners association can authorize more,
Right.
but they cannot take away this.
These are the flags that cannot be denied by any homeowners association under any circumstance.
In the state of Florida, you are allowed to fly the United States flag. You are allowed to fly the Florida state flag. You are allowed to fly the flag of any of the armed forces of the United States. You are allowed to fly a POW flag for missing in action prisoners of war. And you are allowed to fly a flag in honor of any first responder, whether it's police, fire department, medical personnel, stuff like that.
Well, they added a new flag. They added another one.
Which one?
They added a flag that has never been there before. You are also now allowed to fly the Patriot Day flag, which is to honor September 11th.
Okay, good. Didn't know that. So those are the ones that a homeowners association cannot deny you. Now, like every other bill or every other law, there's a lot of little technicalities, and I won't get into all of them, but just to give you some idea of how detailed this stuff is, they say that the flag cannot be larger than 4.5 by 6 feet. They say that it's got to comport with the United States Code 36 USC Chapter 10, which is patriotic customs. That's the flag code for the United States. So if you're going to fly, let's say you want to fly a Marine flag and a United States flag, not that a Marine would ever make this mistake, but just for purposes, you have to fly the American flag on top. It's always got to be the top flag if you're going to have more. It also allows you the right, unless it creates an obstruction, it allows you the right to put a up to 20-foot flag pole on your property on which you are entitled to fly 2 flags. Correct. So it was really kind of a slap in the face to homeowners associations that did not want this. Now, in their defense, you had people who were trying to, really abusive with their own property and obnoxious, whether it's, your MAGA supporter that had a 47-foot Trump flag and, F you Biden and blah, 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 thoroughly obnoxious. Or it could have been something like LGBTQ. You have somebody flying a 40-foot rainbow flag in their property. Whatever it was, this law does not validate any of that type of behavior. It's limited, it's restricted, but it basically says we're not going to allow a homeowners association to deprive people of being patriotic in the state of Florida.
Right. Now, there's one other change. Previously, you were allowed to fly one of these, one or the other. Now, with this law, you're allowed to fly up to 2. So it would be the United States flag, and now because of this law, you can fly, like Mike said, a Marine Corps flag, a Navy flag, a Patriot Day flag. But I think if I'm reading the statute correctly, and the 3rd DCA will eventually tell me if I'm wrong if anybody brings it up, I don't think you can fly like an Army and a Navy flag. It has to be a U.S. flag, United States flag, and one of the other ones as well. So that's the
minutia aside, I think we've hit the point and beat it to death. Yeah, let's get on to our next one, which is really the biggest one that we're going to talk about today. We're going to spend more time on this than any of the others. This is House Bill HB 543, which is affectionately known as the constitutional carry law. So there's a lot of misunderstanding about what this law means. And primarily that is because of the political filter that it is viewed from.
Right.
And if you remove the politics from it and you simply look at the law, it's pretty damn plain. It changes virtually nothing. There are some changes, and to some of us, they can be significant, and we'll talk about them. But overall, all that this law does is eliminate the requirement that somebody have a permit to conceal carry. It does not mean that anybody and everybody can conceal carry. If you were not qualified to get a permit in the first place, you cannot conceal carry with or without a permit. If you are, let me repeat that. If you are a disqualified person, if you are somebody who could not qualify for and secure a concealed weapons permit, constitutional carry does not authorize you to carry a concealed weapon. You are still a disqualified person. So who's disqualified? Give us some categories, Ed.
Well, convicted felons, for one.
Convicted felons, anybody who's under 21 years old cannot carry a concealed firearm.
Correct.
People who have been Baker acted.
Right.
People who are under domestic restraining orders.
Mm-hmm.
There are. Go ahead.
I believe the one of the issues is like what happened with Hunter Biden and others. It's not just him. Others who have lied about their drug use. You were not going to qualify for that. And
then there are even people who are qualified,
right,
who, because of their behavior, disqualify themselves. So you and I both have concealed weapons permits, mm-hmm, and you and I are both responsible drinkers. But if we were not, and if we went out and got hammered, even though we have a concealed weapons permit, if we are intoxicated, we are not allowed to carry that weapon. That is a crime.
Right.
So again, even if you're a qualified person, you can disqualify yourself by your own behavior, and you can disqualify yourself by your location. So hang on a second. Constitutional carry does not change the fact that whether you had a permit or not, you still cannot bring a gun into a courthouse,
Right.
or past TSA, or into a school, or to a professional sporting event, or to a bar, or to any of the places that were previously disqualified places. So that's exactly where we are. None of that has changed.
Right.
Constitutional carry does not make it lawful for anyone and everyone to carry a gun. Understand that very clearly. This is a misnomer. It is a lie. It is a political spin with a political purpose.
Right.
It is unfactual. It is untrue. And it is completely inappropriate for people to say. That said, there are some things that constitutional carry did eliminate. If you'd care, go ahead. If not, I'll continue.
Well, I just wanted to bring up, I don't know if you want to bring up one of the issues that I saw that was kind of buried in the minutia of it, is what they're doing as far as the reciprocity with.
Well, let's save that for later, because that's the tail end of this. But I meant more about how has constitutional carry changed the idea of concealed carry. And the point I was trying to get to was, in order to get a concealed weapons permit, apart from being a qualified person, because you would be denied if you weren't, but you have to pay a fee. So constitutional carry eliminates the need for you to pay that fee. You have to go through a background check. It eliminates the need for you to go through the background check.
Right.
Again, understand, it does not make it lawful for somebody who could not pass that background check to carry the gun.
Right.
That's still a crime.
To be crystal clear, you still have to pass a background check to purchase.
To buy a gun. Right. But new gun purchase aside, because we'll get to that when we deal with reciprocity at the end of the discussion. But that aside, the other thing that it did, so you don't have to pay the fee, you don't have to go through the background check for the permit, but the third thing that it does that I personally have a little controversy with is it eliminated the need to take the gun safety class.
Correct.
So prior to constitutional carry, prior to HB 543 becoming a law in the state of Florida, if you wanted to carry a concealed weapon lawfully, now remember, that's the key here, because criminals, people who are going to break the law, don't give a crap about the law. They don't apply for permits. They don't ask for permission.
And we've represented plenty of those.
Right. That's the whole point. So if you were to apply for the permit, you would have to pay for it. You'd have to go through the background check, get your approval, and then you'd have to also show that you took that class. Now, I took the class. You took the class. We're both avid gun owners, and we're both responsible gun owners. What is your, on a scale of 1 to 10, 10 being totally prepared, know everything you need to know, and 1 being you're a complete amateur, where do you fall after that 4-hour gun safety class on the scale of 1 to 10 with regards to gun knowledge? If you have nothing else other than that class.
If I went in as a 1, I came out as a 2, because they didn't really do much.
Exactly.
Something.
So, right. So now I personally think that they should have had much more stringent requirements even before. The gun safety class was not enough. It's better than nothing, but it ain't enough. It never was enough.
Put it this way. Nobody has ever failed the gun safety course unless you had an IQ under like maybe 45.
Yeah, or maybe you accidentally shot somebody in the class.
Or you were drunk, or you were high, or you fell asleep.
Right. So, I mean, you guys, anybody who's listening to this can liken the gun safety class. If you've ever had to take a driver improvement school, the 4-hour driver class, because you got a ticket and you either didn't want to go to court and you opted out, or the judge ordered you to take it, it's a pain in the ass, but you don't come out of it a better driver. Okay. There's no practical effect to that. The truth is, nobody even knows if it was you who took the class. Somebody else could take it for you.
Correct.
Another parallel would be if anybody here has taken the boating safety class. If you've taken that, again, it's the same thing. It's a multiple choice test. There is no demonstration of proficiency or knowledge or ability to actually captain a vessel when you take that class, yet it's enough for you to operate a vessel in the state of Florida. That's the only requirement. So, these are substandard things that should have been addressed prior to this. But right now,
I want to
Right.
mention something before we go into the other stuff, but just briefly, you still now, even if you're using, and as Michael says, constitutional carry means you don't need the permit. You just carry concealed because you are an American citizen and you qualify otherwise. But you are still required to have identification. You cannot constitutionally carry concealed without an ID. And you don't need the concealed weapons permit, but you still need either a Florida ID or a Florida driver's license while you're carrying concealed. So let's say you're walking, you're on your bike and you're riding your bicycle all the way from your house to Tropical Park and you want to carry, you better take your driver's license even though you're not driving, because you still need an ID so that officers can identify who you are.
in fact, you're obligated to identify yourself. That's part of the new law. It is a requirement.
Right.
Where it used to be, the requirement previously was all you had to do was have your concealed weapons permit.
Correct.
That was your identification. You did not need to show a driver's license.
Correct.
So, but remember, the CWP also has your photograph on it. So,
right. So that what I'm trying to say is that in that regard, they're still make sure that they safeguarded that if you're carrying concealed, that the officer can identify who you are, so that they can see. If
they need to be. So what's going to happen as a practical matter is when you get pulled over. So like, here's my protocol. I don't carry very often, but when I do, if I get pulled over, if I come into contact with a law enforcement officer, I always advise that I have a weapon on me. And I ask the officer, what would you like me to do? In the case of a traffic stop, I have my hands on the steering wheel, right? Both hands. And when he approaches, my window's already down. When he approaches, I say, officer, before I do anything, I want you to know I have a concealed weapon. I have a permit. Please tell me what you would like me to do. I don't want any misunderstandings here. By the way, just as a little pro tip, not as a guarantee, I've never gotten a ticket when I've done that. Not once. Every officer I've ever done that with has always been delighted in my level of respect and my level of transparency.
It wasn't because of the folded $100 bill that you put underneath your driver's license.
No, that would have landed me for felony bribery. But again, cops, listen, cops, the number one thing on any given police officer's mind in any citizen encounter is going to be their own safety.
And I think helps a lot, especially in today's day and age. So many people disrespect officers that when they run into somebody who's respectful, they really appreciate it.
So my point being this: once you tell them that you have the weapon, whether you have a permit or not, here's the issue. You got to figure out whether or not you got to know in going into it, whether or not you are a disqualified person, either because of your past or because of your present situation, like intoxication. Again, if I'm DUI and I'm in possession of a firearm, I'm not just getting a DUI, I'm also getting possession of a firearm by an intoxicated person.
Even with a permit. Remember that.
Even with a permit, it's irrelevant. So again, you have to make sure you're not a disqualified person. You have to make sure that you are not engaged in disqualified behavior, and you have to make sure you're not in a disqualified place. So if all of those things come to fruition, you're great. But what you can't do anymore is you can't say, no, I'm not talking to you. No, I'm not giving you my ID. We've all seen these things where you got some snarky lawyer that does an advertisement where they have somebody hold a sign up to the window on the car that says they don't want to talk to the cop. And it's just literally handwriting that says, I'm not talking to you. I don't have to talk to you. Here's my license. Give me a ticket. You don't want to start that way. You don't want to end that way, especially when it comes with guns, when it comes to firearms or weapons of any kind. Because remember, a CWP is not just for guns. It's also for deadly weapons. And that could be any of a number of things. The statute's very broad as to what a deadly weapon could be. But we're talking about concealed carry now. So if you are not a Florida resident, let's say you live in Alabama and you're visiting Florida, or you live in California and you're visiting Florida, you don't need a concealed weapons permit in the state of Florida, even as a non-Florida resident. But you still have to be a non-disqualified person, engaged in non-disqualified behavior, and in a non-disqualified place. So what has constitutional carry really changed? It's eliminated the initial background check. It's eliminated the $200 application fee. It's eliminated the alleged gun safety course. That's it. That's all it's eliminated. Now, Ed's going to give you two reasons why it is a good idea to maintain a concealed weapons permit.
Well, right. Well, I don't know if you know what two reasons I was going to say, but I think
I do, because there's really only two, but go ahead.
One of them I'm sure we can agree on is that with a concealed weapons license, you are already pre-qualified. Whoever you're buying a firearm from knows that you've been qualified, that you can own a firearm. So there's no 3-day wait. That's one of them. Now, the other one that I was actually going to suggest, and I don't know if you've thought about this, Michael, but I would suggest everybody who wants to carry concealed, get your permit, because you may have something in your background, in your history, that you don't even remember that would disqualify you from owning a firearm. But if you apply for the permit, it'll come back and it'll tell you, hey, by the way, you've got this going on, and you'd rather know about this before you get arrested by a cop, and straighten it out if it's something you can straighten out. But the last thing I want to let you know is that the bill deletes the reciprocity requirement that limits recognition of CWL issued by other states to only those states that honor the Florida CWL. Right? So that also is eliminated by this bill.
So the two reasons that I believe it's a good idea to maintain a CWP, and Ed brings up a very good point that I didn't actually even think of. So thank you. And I want to restate it just to make sure, because it really is a good point. You never know.
I get lucky sometimes.
And by the way, it could even be, and I've seen this many times in my career, I'm sure you have, Ed, where people get pulled over and somebody's got the same name or the same date of birth, or somebody mistyped something in the system and it appears that you did something that you didn't do. And so Ed raises a very good point. It would be better to know that before you're in the moment with the cop on the roadside. Because I'll tell you right now, when they ask you, do you have anything in your past? And you say no, and they are looking at their computer and it says yes. Now you're not only behind the 8 ball, but you're behind the 8 ball squared.
Yeah.
So
you're behind bars because you're going to get
it's a problem. But so the two main points are, number one, reciprocity. Other states outside of Florida, unless they too are constitutional carry states, which by the way, Florida is now the 26th state to become constitutional carry. So there is a majority of the United States now that are constitutional carry, but there are still 24 states that are not. Those 24 states, of them, may or may not have reciprocity agreements with Florida. But if you do not have a permit, there is no reciprocity in those other 24 states, whether they have it or not. You need that permit in order to have reciprocity. So if you're never going to carry a gun outside of Florida, that's not really an issue for you. But the other issue is, as Ed mentioned, purchase. And I want to make 2 points on purchase. The first is, just like constitutional carry does not authorize disqualified people to carry, it also has absolutely zero effect on purchase of firearms. First off, the state of Florida does not regulate purchase of firearms. Purchase of firearms is regulated by the federal government. That's number one. Number two, if you have a concealed weapons permit, you have already gone through the background check and you have already been qualified.
Right.
So if you go to purchase a firearm, whether it's at a gun show, whether it's a private purchase, whether it's at a gun store, it doesn't matter. You do not have to wait the mandatory waiting period that you would have to wait if you did not have a permit. Right. So if you're in a constitutional carry state like Florida, but you do not have a CWP and you go to purchase a new gun, you will have to wait the waiting period. However, if you maintain your CWP, the waiting period is still waived. So again, if that's something irrelevant to you, those are really the only two reasons to pay the fee and maintain the permit. Otherwise, there's really no point in it. So have we beaten that to death, or do we need anything more?
Oh, I've beaten it to death. Honestly, it's not that complicated of a bill, and the media, both sides of the media, have tried to make it more complicated.
They have turned it into it. Well, because again, that's called, and the word for it is politicking. Yep. That's what it's called. You have factions that are pro-gun that are touting it, and you have factions that are anti-gun that are blowing it up. We're not here to do either of that. We're just giving you the facts. And the facts are, if you are not allowed to have a gun, it didn't matter whether you had a permit or not. You weren't allowed to have it with a permit. You're not allowed to have it without a permit. You weren't allowed to have it with constitutional carry. You're not allowed to have it without. Right. You're either disqualified or you're not disqualified. This is black and white. So let's get on to our next one, HB 949, which I call the golf cart law. So this is a great one, right? I mean, anywhere you go, I don't know. I guess I can't really speak to anywhere because I have a limited area. But in my area, there's a lot of communities that have golf carts.
Yeah.
And there's a lot of families that use their golf carts. In fact, when I lived in Keystone, I had a golf cart. And it was a lot easier for me to use my golf cart to run around Keystone than my car. And even sometimes, like, I would go every year to buy a Christmas tree, actually 2 of them. Well, let's call them a holiday tree because I really didn't celebrate Christmas. I celebrate the whole season. But that's neither here nor there. So I would go get the tree, and rather than putting it in my car, it was a lot easier to strap it to the roof of my golf cart. Even though I had to drive a couple of blocks down US 1 to get to the place where they were sold. But I didn't care, and I took the chance. Well, because of the pervasiveness of golf carts, which are absolutely everywhere now, and a lot of kids are driving them.
Right.
They have now passed HB 949, which is what we call the golf cart law. And basically what they've done now is they have said that golf carts are now considered motor vehicles under Florida statutes chapter 316, which means that they are enforceable as any other motor vehicle under chapter 318 in terms of penalties. You are no longer allowed, as of July 1st of this year, you are no longer allowed to operate a golf cart anywhere on any street, even in a private community, if you do not have at least a learner's permit or a driver's license if you are age 15, 16, or 17. So if you're under 18, you can only drive a golf cart lawfully if you have a learner's permit or a driver's license.
Which is the change, because prior to that,
there was no requirement.
Even if you were younger than 14, you
right.
could.
Now you cannot. And as a 14-year-old, you are no longer allowed to legally operate a golf cart in the state of Florida. Now, if you are 18 or older, you do not have to have a driver's license.
Right.
But you do have to have a valid issued state ID.
Correct.
And that's going to tie into the last bill that we talk about, which is SB 1718, which is our new Immigration Act. Because to give you a little bit of a preview on that, Florida has now basically said we are not honoring undocumented aliens, undocumented people who are not either United States citizens or bona fide residents or legitimate tourists. People who are lawfully in the United States, we're no longer allowing them to drive vehicles in the state of Florida, and that would include golf carts. But again, we'll get there in a little bit.
Yeah, because I also have an issue with one of the aspects of that bill.
So the only other thing that you need to know about the golf cart bill is relax, kids and parents. Nobody's going to jail. It's a non-criminal traffic infraction. If anybody does get caught, if your 14-year-old or your 13-year-old takes the golf cart, they'll get a ticket. But they will not be going to jail unless, of course, they run someone over or do something horrible, flee from the police or pull out their constitutional carry gun that they're not supposed to have because they're a disqualified person and start shooting. Shy of that, the golf cart's basically easy peasy lemon squeezy. Now a little more controversial. We get in.
Wait, there's an issue that I have with this law about
Go ahead.
driver's license. And I'm trying to find it. I apologize. I could have sworn I highlighted it, but I didn't. One of the things that's buried deep in this bill is that the state of Florida will not honor reciprocity of driver's licenses from states that do give illegal immigrants driver's licenses.
Right. Well, again, we're going to get into that in the Immigration Act.
You were done with the.
No. We'll do the Immigration Act last.
Oh, I thought we were doing the Immigration Act.
No. That we're going to get into for sure.
Okay,
so let's jump over to HB 1521. This is a controversial one. I'm warning you in advance. This is called the Safety in Private Spaces Act. And basically, whether you like it or not, for better or for worse, again, we're not here to opine one way or another. We're just calling balls and strikes here and telling you what the law is. Florida has now officially defined women as people who are born and produce eggs, and men as people who are born and produce sperm. That's the basic nuts and bolts of it. And they have said, if you are a man, you must use a men's bathroom. If you are a woman, you must use a woman's bathroom. Anybody can use a unisex bathroom as long as it's clearly marked, but men ain't going into the women's room and women ain't going into the men's room in certain places. And basically it identifies them as schools and public buildings. So basically courthouses, schools, things like that, that's what this applies to. It's not necessarily applicable to private businesses, mom and pop shops. But if you're going to have a courthouse, if you're going to go into City Hall, they're requiring government buildings and schools and academic institutions to limit men's room to men, biological men, and women's room to women, biological women. There are exceptions. There's an exception for children under the age of 12. They are not held accountable here one way or another. There are exceptions for senior citizens and for people with, quote, developmental disabilities, whatever that means. But the point is, it's not a blanket rule. I think the spirit of it basically is that they don't want biological men using the pretense of identification to be able to commit lascivious acts or be perceived as committing lascivious acts, whether they're doing it or not. There's the intent of, there's the viewer's perspective, which can be different than the intent of the individual. So that's basically their thing. You are no longer allowed to willfully enter a restroom that is designated for the opposite biological sex. But there's also an exception. You can do it unless you are asked not to. So the exact word is refuse to depart. You have to be asked to leave in order to violate this law.
And look, Mike, if we're going to look at it, let's if we can, let's take it away from this specific aspect. If you look at the way the bill was drafted, I think it goes back to our this country and the way that we our system of laws and the way that this country was created. Notice it says that this is in public or government buildings and schools. And I think that's because most of these places are places where people are required to go to. And so, we want to protect people that are there because they have to be there. But if it's a public place, and so, for example, if you don't want to share a bathroom with a transgender and this specific restaurant or cafe allows that, you can choose a separate cafe.
Exactly.
Cafe,
I want to go back
to go into that bathroom. You go and you choose the ones that do.
I want to go back and say that it's schools, jails, prisons, and domestic violence centers.
Okay.
That's specifically what's enumerated in this law. And this is a criminal.
If the businesses want to cater to transgenders and anybody who wants to use opposite sex bathrooms,
right? This is not for private business.
And they can do a unisex bathroom if they want. Just build one extra bathroom, and then everybody's happy.
When it comes to schools, the law requires disciplinary procedures for violations to be developed by the individual school districts. So it's not a blanket rule for every county in the state of Florida. We have 68 or 69 counties. Each of them can come up with their own rules, but they do require that there be some disciplinary protocol put in place for violation in schools. The penalty for a willful violation when you are asked and you refuse to depart, it's a second-degree misdemeanor. So it is the lowest level criminal offense that we have in the state of Florida. The maximum punishment for a second-degree misdemeanor in Florida is 60 days in jail, a $500 fine, and 6 months probation and a permanent criminal conviction. But I would dare to say that you pretty much have to be Al Capone to get that kind of a sentence for a second-degree misdemeanor. Usually they're a slap on the wrist and get out of court.
I've never seen one in 20-something years. I've never seen anybody.
So that gets us through the Safety and Private Spaces Act. Now we get to one that I really like. This one I hold near and dear to my own heart. This is Senate Bill 766.
766.
Senate Bill 766 is the school bus infraction detection system. So basically what they did was they passed a law that now allows school districts to arm and equip school buses with portable cameras that are permanently affixed to the bus that take streaming video and photos of vehicles while the bus is moving. So you may have seen this. I mean, everybody's pretty much familiar with traffic red light cameras.
Right.
And I'm going to use them as an analogy in a little bit. But what you may or may not be familiar with is that in some jurisdictions, like, for example, here in Metro-Dade County, maybe a lot of the smaller ones don't have them, but some of them do. There are cars that are equipped with cameras on all four bumpers of the vehicle, on all four fenders of the vehicle. And those cameras literally do nothing but scan license plates. And then they interface with the computer and tell the officer in the car when they have a hit on a red flag, whether it's a stolen vehicle, an Amber Alert, the registered owner's license is suspended, any of a million things that can pop up, those cameras are scanning 24/7. Well, what this new SB 766, the school bus infraction detection system, does is it allows school buses to be equipped with these cameras so that asshats that blow by a stopped school bus now get caught on camera, and those videos can be turned over to a local police department, and those idiots can be issued the citations they deserve. Although, frankly, I think they should be dragged out of their car and beaten. But
by the way, not can be, they must be turned over to law enforcement, because unlike the red light cameras are not turned over to law enforcement. These are going to be turned over to law enforcement, and law enforcement will make the determination.
No, they have to do that with red light cameras too, Ed.
I thought they changed that. I thought they were.
No, they have to. Each department, if you're going to use them in your municipality, there has to be an assigned officer that reviews all footage before an infraction alert can be sent out. So I don't know if they need to review them to send you the initial civil demand letter for the $147 or whatever it is. But I know if they ratchet it up to a ticket, it's got to be reviewed by law enforcement.
Same thing here. Same thing.
And that's what this requires. So it requires that if the school doesn't mandate that the school districts do it, but it gives them the authority to do it. And if they choose to do it, then it lays out the protocol that they have to develop in order to make it legit. So if they choose to do it, they have to outfit the machinery. They have to have a local agreement. They have to have a cooperative agreement with the local police municipal force. They have to have an assigned officer that's going to review the footage, and it's all got to be done by the book. And if it is, then it's going to be done exactly the same way that red light camera tickets are done. You're going to get a notice of the infraction in the mail. If you pay it, goodbye, good luck, no record. If you don't pay it, then within 30 days, it gets reissued as a uniform traffic citation. And now you have to go through the court system. You face more penalties, points, et cetera, et cetera.
There is good news, Michael.
Tell me.
They lowered the civil penalty. So the civil penalty is now $225 for doing it. $200 goes to the school to maintain the equipment, and the $25 goes to the Department of Education. The fine used to be $265. So they've lowered it a couple of $40. My math is correct. So there's a little bit.
Little something for everybody.
There you go.
All right. So now here's one that I know very little about, but I want to bring it up, and I'm going to pull up my notes. I have a little cheat sheet here. But I want to talk about SB Senate Bill 1416. And this is the new revisions to Florida's alimony laws.
Yeah, hold on. Go ahead.
I don't practice in the family arena. Ed does a little bit of family work. But I wanted to bring it up only because it's pretty significant. They made some major changes.
Yeah.
Perhaps the biggest being that they have eliminated what was called permanent alimony. So it used to be that if you met the criterion, whatever it was back in the day,
if you were married for over 17 years,
whatever it is, a judge could say you have to pay your former spouse for the rest of his or her life X amount of dollars. That has been eliminated. There is no longer such a thing as permanent alimony in the state of Florida. We do have several different types of alimony. There's temporary alimony, what they call bridge the gap, or rehabilitative and durational. And they have now capped rehabilitative alimony, which is another big one. Let's say you marry somebody and you have no career, you have no education, you become a housewife or a house husband, and the other spouse, makes all of the money and pays all the bills. You used to be able to apply for what was called rehabilitative alimony, meaning, well, I need to learn how to support myself. I need to go to school. I need to have enough funds to be able to develop a career. That's now been capped at 5 years, whereas there was no cap previously.
Right. The problem was, Michael, that there was no uniformity. Depending on what judge you got, you may be, ordered to pay rehabilitative alimony of 10 years, or you may be ordered to pay rehabilitative alimony of 1 year. And the criteria were the same. It really depended on the judge. I think that part of it, most family lawyers will agree is a good thing because it gives us a little more certainty. And there are a couple of other things, if you don't mind me jumping
No,
in.
please, because I know very little about this.
So short-term marriages used to be determined as 7 years or less, and a moderate or middle-term marriage was 7 years to 17, and a long-term was over 17 years. Anything over 17 years, you pretty much were guaranteed here in Dade County anyway that you were going to get permanent alimony. They've changed it. That's one of the major changes they've made now, is that now, and I'll find my notes here, a short-term marriage is determined as, where are my notes? I'll find it I had it a second ago. I think it's 0 to 10 is the short term. The moderate, yes. So short term is 0 to 10. The moderate is now 10 to 20. And the long term is now 20 or more years. A couple of things that also they changed. Bridge the gap alimony is still the same. That one was actually limited to 2 years no matter what. That was good. Rehabilitative is now limited to 5. And there is no durational alimony if the marriage lasted 3 or more or fewer years. And if the marriage lasted more than 20 years, still, or over 3 years rather, still, short-term alimony must be no more than 50% of the length of the marriage. If you're married for 10 years, it can only be 5 years of alimony. If it's a moderate marriage, it's only 60% of the terms of the marriage is how long you'll have to pay alimony. And if it's a long term, remember that used to be permanent, is now maximum 75% of the term of your marriage. So those are some major differences that that they made to this. And then there's a couple of others, and I'm going to make this real fast. One, it removes, so this is something you used to have to do, you no longer have to do, the requirement that parties in a supportive relationship are residing together. So in the past, you get divorced, your wife starts dating some guy, and they've been together for 10 years, 15 years, which people do, but they choose not to get married so that the ex-husband has to keep paying alimony. Even if the only way you had to do, the only way you could prove that she doesn't need the alimony is if the boyfriend / common law husband was living with her. They've removed that. So if she's got a boyfriend that pays her bills and takes care of her, you can bring that up and show it. And even if they live in separate homes, it'll show that she doesn't need your alimony anymore. They added that the court may consider whether the obligee, the person you're paying to, or the other person have acquired or maintained a joint bank account. So if you say he's just your boyfriend, but you have a joint bank account, that also means no more alimony. It clarifies whether the court should consider the extent of the obligee and the other person have financially supported each other. So how much do they pay for each other? It adds that the court consider the extent of the obligee has paid the obligor, has paid the existing alimony award or has failed to do so. And it also adds that the court may consider the extent to which the person getting paid the alimony or the other person has provided support to other family members. So if you're paying alimony to your ex and she's taking care of her sister, you can now bring that up and say, whoa, judge, I'm giving her alimony, but she's paying her sister's, car payment. Well, those things before you couldn't bring up, but now you can. And there's a couple of other things, but we don't have the time on this show. It's
right. And so the only notes that I have very few notes on this, because again, it's out of my ballywhack, but I figured people may want to know about it.
Right.
And I always recommend talk to a family lawyer about family law issues. But that said, the things that I noted were, without running through some of the ones that you just mentioned, the new law lists a whole bunch of criterion that the court not only can consider, but stuff that the court must consider,
right,
which it was not even allowed to consider previously.
Right.
2, it is now said that the party seeking support has a burden of proof to show their need for support and the other person's ability to pay. It's now a established firm.
Well, that was always there, but it was in case law. Now it's
this is established in the law.
Right.
I also want to note that prior to this law, Florida was only one of 7 states in the country that had permanent alimony. So 43 other states had already done what Florida just now did. So we are now the 44th state to eliminate permanent alimony. In case you were wondering, the ones that still have it are Connecticut, New Jersey, North Carolina, Oregon, Vermont, and West Virginia.
Think about the way it was here, Michael, just briefly so I can interrupt. Imagine you get married at 20 years of age. Now you get divorced at 40. Under the previous law,
You're paying for the rest of your life.
The ex could choose never to work again. 40-year-old person who's actually can work and can provide and could choose to say, no, I'm not. And they could get a boyfriend or a girlfriend, let the boyfriend or the girlfriend pay all their bills, and get a sugar daddy or a sugar mama and not worry about it, and still get your ex to pay you or your alimony. And that just wasn't fair.
Well, that's, again, folks, if you have family law questions, you need to talk to a family lawyer or somebody like Ed who knows a lot more than me about family law. I'll tell you what I know. I want nothing to do with it. That said, let's get to our last law we're going to talk about, which is another controversial one. And again, we are not politicking here. We're just umpiring. We're just calling balls and strikes. Senate Bill 1718, which is our new Comprehensive Immigration Act. Florida has really come down hard on illegal immigrants. The new law does many things, but I'm going to give you a few of the highlights. One is that it is a requirement now, if you are a business owner with 25 or more employees, you must use the E-Verify system to verify somebody's legal status in the country. And if you hire anybody who does not meet the criterion, or if you fail to use the E-Verify system, again, you have to have 25 or more employees to be subject to this law, then it is punishable by $1,000 a day fine. So that's a pretty hefty smack, and that's per individual, by the way. So if you're a business with more than 25 and you have 10,000 a day for every day that you keep somebody employed without complying with E-Verify. It also will suspend the business license of the business if you're caught in violation. And it makes using any fake ID to gain employment. So now not just the employer, but the potential employee, if they use a fake identification, that becomes a felony charge here in the state of Florida. So be careful with your fake IDs now, especially if you're not a United States citizen. You can be looking at felony charges just for trying to pass one off.
Yep.
It enhances human smuggling penalties. If you are caught with 5 or more people or one minor. So in other words, let's say you're ferrying a boat from the Bahamas or from Jamaica or from Puerto Rico, or not Puerto Rico, but it could be Puerto Rico just with non-U.S. citizens. Right. If you're caught transporting non-U.S. citizens, 5 or more, or no matter how many you have, if there's one kid, it's a second-degree felony. That's punishable by up to 15 years in state prison. So it's a pretty serious offense at this point. But bigger, more practical purposes, it now has restricted the state's ability to issue any type of identification, specifically not just driver's license, which are flat out prohibited, but even a Florida state ID or a municipal ID. It prohibits municipal governments from doing it too. Cannot give any legitimate identification to anybody who is not a legal resident or citizen or valid tourist in the United States. So if you were here illegally, Florida law now makes it illegal for anybody to give you any type of identification card. It also invalidates any out-of-state identification card that was issued to an illegal. So if you're in a sanctuary state like California or New York or wherever, and they give you a driver's license, Florida will not recognize it. In fact, the statute specifically calls out Connecticut, Delaware, Hawaii, and Rhode Island as states that issue driver's licenses under the guise of a, quote, driving privilege only, as opposed to a actual driver's license. So it's not an identification card. It just authorizes you to drive, but not in the state of Florida. Florida will not recognize it.
But let me just point something out, because that's one of the things I had an issue with this bill. So if the state that issues the driver's license only IDs issues those to illegal immigrants, the part of the statute I'm about to read to you is fine. It makes sense because you could see it right on the ID. But when these states start changing that and they start just issuing a straight up regular driver's license to illegal immigrants, I have a problem with this part because listen to what it says. Prohibits a person from operating a motor vehicle if his or her driver's license is issued by another state which exclusively provides such a license to undocumented immigrants who are unable to prove lawful presence in the United States when the license are issued. I could see a scenario where somebody's coming from one of these states who only has their DL from that state, but they don't speak the language well. They don't speak English very well. And some cop says, well, if you can't prove to me you're not an illegal immigrant, I'm going to arrest you. I really have a problem with this.
There's no question, and pardon my language, but this is going to be a shit show.
It is.
It's going to be a shit show for law enforcement, and it's going to be a shit show for a lot of people.
It also, by the way, it also prohibits the state of Florida being a sanctuary city. It says it right there. Prohibits a county or municipality from providing funds to any person, entity, organization for the purpose of issuing an identification card or document the person who's no proof of lawful residence. It requires a person who is in custody with law enforcement to submit to a DNA sample. It requires any hospital, and this I understand. Notice what they say. It requires a hospital that accepts Medicaid.
Right. They're gonna try and collect the money back from the federal government.
To include a question on the admissions registration forms inquiring as to whether they're a U.S. citizen or not. And the reason,
right. So it doesn't, but to be clear, it does not authorize a treatment facility to deny treatment.
Correct.
It just requires them to keep a record of the treatments that they've given to illegal aliens.
Correct. And I can see that because they want to see how many illegal aliens are actually using the Medicaid benefit.
How much money is being spent. And I suspect that they will ultimately at some point be filing a lawsuit against the federal government to try and recoup those monies.
Right.
But I don't want to get any more into the minutia of it other than to
also
say
complicated, but I agree with you. It's a shit show.
It's very complicated. It's going to be a very difficult thing, but again, it is what it is. It's one of the new laws. Florida is, we've become a pretty much, I would say it's fair to call us a law and order state, at least compared to sister states like New York and California, who are far more liberal in their governing philosophies. Anyhow, we're over the hour mark. We've hit our 7 new laws. We've done our civics refresher course, which hopefully everybody enjoyed.
Keep in mind, we didn't cover everything that every single one of these bills had, because some of them has a lot of other stuff in there, and it was just, we don't have enough time.
And just remember, again, when it comes to constitutional carry, I really want to dispel that nonsense that it has now made Florida the Wild West. We were the Wild West before constitutional carry, and we'll be the Wild West after, and it's not because of the law, it's because of lawbreakers.
Right.
People who are going to break the law are going to break the law regardless of what the law says. That's the whole idea. But for that, Ed and I would have to have real jobs. So with that said, I want to thank everybody for your attention and your time today. Ed, it's good to see you. I'm glad that we were simpatico in costumes today. Next week, we do have a special guest coming on, and we're going to talk about much more about the legislative process, because he is the liaison from the Florida Association of Criminal Defense Lawyers to the legislature. So we should have an interesting discussion on the effect that we have in terms of lobbying and how we actually get things done and what roadblocks come up. It should be really interesting, and I'm looking forward to it. Just as a programming note, the following week on the 24th, I have a court conflict, so we will not have a show. Anyhow, again, thank you all for your attention. As soon as our producers are able to develop a link for YouTube, we will upload that onto social media. We thank you for your time. We hope that you guys had a really good We Kicked England's Ass Day weekend celebration. And we look forward to struggling through this nightmare of a heat wave. Stay cool, be cool, and don't carry a gun unless you are qualified to do so. We'll see you next week on the 17th for episode number 71. Thank you, Miami Communities Newspapers. Thank you, audience. And thank you, Ed Martinez.
All right. Thank you.